All right, I think that's good enough. So welcome everybody. Thank you very much for joining us here at Garfunkel Wild. My name is Rob Del Giorno. I'm the chair of our compliance group here. I'm joined with me today is my colleague Celia Morel.
Welcome everyone.
How are you all doing today? Thanks for jumping in. This is our second installment of our compliance webinar series, and we're really excited to keep this going. We have a great topic for you today. We're also going to, kick it off with a little bit of an update on what just, popped here in New York. And we see the questions coming in. Please, some housekeeping. We'll start it right now. If you have any questions about the presentation, please put it in the Q&A section. And we can answer you right away with the first question, and I have it also posted in the chat is, yes, the slides and the presentation will be mailed out within a couple of days to all of our registrants. So this month, we're going to be talking about some compliance program obligations under managed care agreements. Next month, we're going to bringing you my partner, Susan St. John from our Florida office to talk to you about some Florida telehealth care rules. And then in March, it's time. We need to do a roundup here on developments in ECRA, the Eliminating Kickbacks and Recovery Act. There's been a lot of things going on the past 6 months, and it's certainly time for an update there. This is something we're doing every month. It's a great place for compliance officers, compliance personnel, and others involved in the industry to kind of come together, get some great information. If you have some topics that you think you'd like us to cover, you can feel free to email us directly, and we'd be happy to take it under consideration. So with that said, anything else to add before we kick this right off?
I think you got all.
All right. Well, thank you. Let's get going here, everybody. All right. So before we get into the meat and potatoes of what we're here for, let's just do a roundup on the New York compliance regs. They went final on December 28th, right in time for the new year. If you didn't attend, about a week before that, we did a presentation on the proposed compliance regulations. It's available on our website. You can always email me. We can get it to you. And it was certainly timely because a week later, we got notified by OMIG that they were finalized, and they're going to go into effect 90 days. So that's going to put us at March 28th, 2023. Very briefly, despite all the comments that went in, there were very minimal revisions to the proposed regulations. So that webinar we did will really give you a good handle on everything. What we saw, okay, so we have some clarification to a definition of effective compliance programs. They kind of broaden it to just, or mention that it's provider characteristics, means their size, complexity, and resources. We saw some minor revisions to contractual requirements. This still presents a lot of issues. I'll tell you, I'm on the phone with the OMIG. They're terrific. And they're going to be publishing guidance, I was told, on a number of these issues. And I went to them actually on a contract issue. And they said we're going to get some more information from them on how they think some of these regulations apply. We saw some minor revisions to the disciplinary standards language, the compliance committee changes, talking about it advocating for resources rather than ensuring them. And reporting violations, thankfully, it was very broad. It was narrowed to only be reported when required by a law, rule, or regulation. And so again, we have some time, but we're busy here updating our client standard policies that they have for compliance programs. But those changes, we have to get those implemented in effect by March 28th, and everybody really needs some changes because there's a lot of minimum standards now. So it's a kind of a good segue to what we're here to talk about today. And everybody sits around, we talk to our clients all the time, and, they lose focus on certain things. Hopefully all of you haven't, but the truth is, I'm in compliance, right? I look to my state law. It says I'm not a mandatory compliance program provider. I don't hit those, either licensure thresholds or dollar thresholds. I'm good, right? Or, hey, I've hit it and I have a compliance program. There's nothing else for me to worry about. Problem is, the majority of you all sign, or our providers at least, are signing agreements with managed care organizations, or Medicare, and specifically here we're talking about the Medicare Advantage organizations and the Medicare prescription drug plans, Collectively, we'll refer to them throughout this as plan sponsors. The plan sponsors have independent obligations, compliance obligations with CMS. And they have an oversight requirement as it relates to its healthcare providers that it contracts with. And so how do they fulfill those obligations? Well, one way is to push those compliance obligations they have down onto the providers. And so today, it really makes sense for you to understand what are those obligations. We'll talk about what those plan sponsors are obligated to do, because it really lets you see how those things impact you. And so where do you all fall into this, and why are you here today to learn about it? Well, there's something called FDRs, right? They're called first tier, downstream, and related entities. A first tier entity is any party that enters into a contract with a Medicare Advantage organization or Part D plan provider to provide either administrative services, or more relevant to all the folks I saw registered today, to healthcare services to Medicare eligible individuals under those plans or programs. Okay, so many of you, whether you're a hospital or you're a provider or a provider group that has a contract, you're going to be fitting into this first tier entity. A downstream entity is a party that enters into a written agreement with persons or entities involved with the Medicare benefit below the level of the arrangement between the MAO or the Part D plan and the provider, or the first tier entity. So think about, a downstream entity could be a first tier entity could be a hospital, and downstream entities could be parties hospitals contract with. And so first tier entities, as you'll see as we walk through this, have compliance oversight obligations with of their downstream entities. And then you have a related entity, probably not really that relevant for most of you, but it's an entity that is related to one of the plan sponsors by common ownership and performs some management functions or furnishes services, leases property, and things of that nature. So really understanding FDRs, maybe you've seen it and referred to and received the attestations over the years, but it's something you really should be familiar with in understanding what your compliance obligations are. And so CMS permits these plan sponsors to contract with our FDRs, people like you, to provide those healthcare services. Under those agreements with CMS, the plan sponsors maintain the ultimate responsibility for overseeing you and your compliance with Medicare program requirements. A plan sponsor is required to include in your contracts, in those contracts with your Medicare Advantage plan, certain contractual provisions to ensure compliance with Medicare program requirements, such as access to records, certain exclusion checks, and record retention, among kind of the broad things that require you to comply with Medicare regulations and rules. But they also have the freedom to impose other compliance obligations and requirements beyond what CMS says is mandated. So maybe telling you have to have a compliance program, or you have to engage in compliance program training. So as I said, to better understand how this impacts you, it's a good idea that we walk through and understand what the plan sponsor's obligations are as it relates to compliance and to CMS, because it kind of really educates you on why they're coming to you and pushing certain things down to you and what you need to be doing. So I'll turn it over to Celia, and she will start walking you through the compliance program requirements.
Thank you, Rob. And with that, we will start talking about what is actually required in compliance programs. So Rob talked about plan sponsors and the fact that they need to have effective compliance programs. So essentially, what does that actually mean? This may sound familiar to you. There are 7 core requirements of an effective compliance program. First, written policies, procedures, and standards of conduct, compliance officer, compliance committee, high-level oversight, effective training and education, effective lines of communication, a well-publicized disciplinary standard, and effective systems for routine monitoring and identification of compliance risks, as well as how the entity will be responding to those compliance issues. So we can jump into that. So first, let's start with written policies, procedures, and standards of conduct. Plan sponsors must have written policies, procedures, and standards of conduct. Those policies, procedures, and standards need to basically include what the plan sponsor's commitment to comply with is with all applicable federal and state standards. Also, it needs to describe the compliance expectations expected of employees, along with how the compliance program is going to operate. Further, you need to have your written policies include guidance on how you will be dealing with compliance issues as they arise and how to communicate those procedures. So you also need to move on to having non-intimidation policies as well as non-retaliation policies when there is good faith participation. So if you have employees who are actually participating in reporting compliance issues or potential compliance issues, you need to ensure that you have written policies for non-intimidation and non-retaliation. Now, these policies need to be distributed within 90 days of hire and annually thereafter. You'll see on the slide that we do have FDRs highlighted, underlined, and the reason being is because that responsibility is getting pushed down to the FDRs, so we want to stress the importance of it, and we can move on to the next.
All right, look, so this shouldn't be anything new to most of you, right? Written policies, procedures, standards of conduct, typical first or second element of either the OIGs or the New York State's regulations for those of you, because I see a lot of the New York State questions flying in. Interesting here is we highlight these things, these 90 days of hire. These are standards you'll see keep getting pushed down, and you'll see a discussion later when I start to explain to you what your obligations are related to this. You'll see, whether you're using the plans or your own, there's some options there. Go ahead. I don't know if you've covered this already, but there's a few other things on the standards here.
So as it relates to standards of conduct, the written policies need to include a description to employees about the plan sponsor's expectation of them when it comes to ethical conduct. There also needs to be mention of mechanisms of proper reporting of noncompliance issues and potential fraud, waste, and abuse issues, as well as assurance that when there are issues, that those issues are going to be reported and addressed and corrected.
All right, so why don't you tell them a little bit about what those plans have in terms of compliance committees and compliance officers? Sure.
So I'm sure this is also not new, but compliance officers have responsibilities as well as compliance committee. So the plan sponsor must designate a compliance officer and a compliance committee to oversee their compliance program and report directly to the plan sponsor's chief executive and other senior management. Now, the compliance officer is responsible for the day-to-day operations of that compliance program. The compliance officer must be an employee of the plan sponsor and may not be an employee of an FDR.
Right. So for all of you out there, if you're contracting and somehow some plan comes to you and wants to grab one of your employees for it, that's a no-no. Okay, that's very clear out there. Go ahead.
And this compliance officer and the compliance committee must periodically report directly to the plan sponsor's governing body about the compliance program. So the governing body is apprised of what is going on, because the governing body must be knowledgeable about the compliance program, the reasonable oversight involved, the implementation, as well as the operation. Training and education. What does this mean? So the plan sponsor must provide effective compliance training and education, including fraud, waste, and abuse, for its employees, the CEO, senior administrators or managers, and the governing body members. General compliance training. It must occur within 90 days of initial hiring and at least annually thereafter. Plan sponsors need to ensure that they have proof of this training. Proof of training could be copies of sign-in sheets, employee attestations, or electronic certifications that an employee has in fact completed the training. And the retention for this documentation, along with other records, is 10 years. Plan sponsors must ensure that they have the records for 10 years.
All right, so this one is a little bit important because there's going to be some nuanced discussion later. So you see we left out FDRs in here. There used to be requirements in the regulations that the training be completed by FDRs. There was a lot of pushback, so at one point Medicare, and you'll still see it, okay? They'll push out to you the fraud, waste, and abuse training online and say, you know, these plans may send it out to you and say, please do this. Well, they came out as a uniform thing to try to reduce the burden. They didn't think that was really working, and so now they've kind of left it to the plans to decide what kind of training a provider or a first-tier entity needs to engage in. But you'll see some of this stuff later, too, about there were things about being deemed and being waived, and I still see it appear when my clients come to me with some of these attestations. You'll be deemed have completed it if you're just a Part B enrollment. It's still in the Medicare published manual. It's not in the regulation. It was expressly removed. So there's some things out there just to be aware of. But let's go to effective lines of communication.
So there must be established effective lines of communication to ensure confidentiality between the compliance officer, the compliance committee, employees, governing bodies, and FDRs. Now, the lines of communication need to be accessible 24 hours a day, and they need to provide for anonymity and confidentiality so there can be good faith reporting of potential compliance issues. Plan sponsors must have a system to receive, report, respond, and track compliance questions or reports of suspected or detected noncompliance, along with potential fraud, waste, and abuse from employees and anyone else that is reporting. They also must adopt widely publicize and enforce a no-tolerance policy for retaliation or retribution against any employee or FDR who in good faith comes forward and decides to report a compliance issue or a potential fraud, waste, and abuse issue.
Right, so you see one of these touching you as a first tier is really in the first one, is they need to be getting this out to you because they're supposed to be making sure they're first tier, you providers who sign your contract know how to get into and effectively report compliance concerns to them. So hit disciplinary standards now.
Yes, so those well-publicized disciplinary standards are very important. You need to ensure that your employees and FDRs, everyone that's implicated, is able to actually see your disciplinary standards. And those disciplinary standards need to describe the expectations for how to report compliance issues and their resolution, along with identifying noncompliance and unethical behavior, as well as they need to provide timely, consistent, and effective enforcement when noncompliance or unethical behavior is in fact found. Some examples, you could choose to provide newsletters, presentations at department staff meetings, have communications with FDRs where you are publicizing these disciplinary standards, have a general compliance training with the individuals, post it on your website. Along with, you may also choose to have posters displayed in rooms such as break areas where employees generally are and can see these posters.
Right, so I just want to address quickly a couple of questions floating in. The plan sponsor is what you would call it says, is the plan sponsor the FDR or the insurance company? I get why it's confusing. The plan sponsor is the insurance company. So if it's Blue Cross, Medicare Advantage, we're referring to a plan sponsor, it would be them, like a Blue Cross Medicare Advantage plan. The FDR is talking about first tier, downstream, and related entities. So if you're, a hospital or you're a practice group or you're a physician and you've contracted with the MAO, with the Medicare Advantage organization, the plan sponsor, okay, you're the FDR, okay, that's who you are. Hopefully that clarifies this. We're getting some questions coming in, good ones about what you need to do in terms of distribution and maintaining proof, and we'll definitely get to that in the next couple of slides when I go through what your obligations are. So you got to enforce these disciplinary standards. You can't just have them on the books.
Right. You can't just be showing them and not enforcing them. So plan sponsors must demonstrate that they will, in fact, enforce the disciplinary standards that they are showing and publicizing. So along with that comes the responsibility of ensuring that there's record retention when there are actual compliance violation disciplinary actions, and the retention on that is 10 years. You need to ensure that you're keeping documents to prove that you, in fact, did a compliance investigation into the issue that was reported. So the record should include the date of the violation, the date the investigation was done, the summary of findings, the disciplinary action that was taken, and the date that it was taken.
All right. System for routine reporting and auditing and compliance risks, something that everybody with compliance programs should also still be familiar with, and certainly these plan sponsors have separate obligations. So can you walk through that?
Yeah, of course. So sponsors need to have and implement a system for undertaking monitoring and auditing to test and confirm that compliance is in fact present. So risk areas, definitely something that you need to focus on. Here specifically, we're underlining FDR oversight and monitoring because plan sponsors need to implement a strategy to make sure that they are able to monitor and audit its first-tier entities to ensure that they are complying with the applicable laws and regulations. And another part to that is that they also need to ensure that the first-tier entities are also subsequently monitoring the compliance of any entities with which they contract with. So that would be the downstream entity. Another factor of that is also the work plan. A plan sponsor needs to have a work plan, and that needs to be generally developed by the compliance officer. The work plan will generally include, but is not limited to, audits that will be performed, the type of audit, the start and end date, whether it's announced or unannounced, the methodology behind the audit, the final audit report, along with follow-up activities.
Okay. So this is kind of like the build-up, right? Why, when we opened this up, we told you it's kind of important to understand the kind of rubric and the framework that's going on in the background between the plan sponsor and CMS. These plan sponsors right here, they have oversight obligations and are responsible for the folks they contract with, especially those providing healthcare services, to oversee and ensure compliance, which is why we start to see this stuff get pushed down on top of our clients.
And now another very important aspect is exclusion lists. Plan sponsors are responsible for checking exclusion lists. And it's not only prior to hiring or contracting a new employee, a temporary employee, a volunteer, a consultant, governing body, or a member in FDR. It has to be done monthly. And the exclusion lists, I'm sure you're familiar with them, the Department of Human Health Services OIG list of excluded individuals and entities, along with the excluded party list system. These are systems that you should be utilizing to ensure that none of your employees are on them.
So on this one, this is one of the ones when you really dive into the materials on these relationships between them. This is one that actually gets pushed down onto, is required to be pushed into your providers that they contract with. But really, you should be doing this anyway. All right, so let me take the wheel a little bit here. Is auditing referring? See some great questions coming in, some funny comments certainly from compliance officers. Yes, they expect you to basically be superheroes and to be able to do everything. So, is auditing referring to billing audits of the FDRs? It can. We'll talk about it a little bit later. It's also ensuring other aspects of things, such as are you running your exclusion lists, etc. All right, let me go on. I want to get through the materials for everybody. Let's see here. So they have to have these procedures and systems for response to compliance issues. There needs to be a system to promptly respond to compliance issues if they are raised, a timely and well-documented reasonable inquiry into potential compliance issues or fraud ways to be done. For these plans and CMS, it's talking about 2 weeks after the data was identified, and a reasonable inquiry includes preliminary investigations, by the compliance officer or somebody they delegate to. They have to take corrective actions in response to it and self-report fraud, waste, and abuse and Medicare program noncompliance. Okay, so that gets us through really an overview for you of what's going on with these plans that you're contracting with, and CMS, because they have reporting, they're going to be audited, and they have to make sure now the auditing relates to their oversight of use. So we've gotten through this, and what's the point of being here if we're not going to talk about what your compliance obligations are as an FDR, right? So your obligations depend on your plan sponsor and your agreement. So look through a number of different agreements, and some plans behave differently. Some have different requirements in their contract, but if you want to go in online and pop up a very large plans, sample Medicare Advantage organization agreement, here's what's buried in there. And I wonder how many of you in compliance are being consulted on these things, or having your counsel, your healthcare counsel, who know compliance, involved with negotiating when provisions like this pop up. So take a look at this one. This is a heavy lift for somebody who's maybe doesn't have a compliance program, maybe that person who's not a mandatory compliance program provider in their state, but you're at the outset agreeing to comply with the payment, billing, and reimbursement policies, the Medicare provider manuals, and the plan that's blocked out. I blocked out the plan's name. The plan's contractual obligations to CMS, and all applicable everything else under the sun right here after. That is a provision that you could drive a truck through and argue that maybe you have every obligation as it relates to compliance as the plan does to CMS. But they make sure they go further. They told this provider who would have signed this is you have to have a compliance program. And you go through and you see your elements of compliance, walking through all of these things, training and education, compliance officers, policies and procedures, all your own, and fraud, waste, and abuse concerns, and oversight of your downstream entities, okay? So right in here, buried in here is telling you as a first-tier entity, if you're contracting out some of these services or things you're providing, you are contractually bound to be looking at and overseeing your downstream entities to comply with certain obligations as it relates to fraud, waste, and abuse. Okay, so that's on the one hand. That is what I would call the more heavy-handed contractual obligations. I've looked at into our managed care department and pulled some of the agreements to see is this sitting in everything, and really for a lot of our providers it's not, or it's morphed, or it depends on your size. And so if you go out and you look at what a lot of these plan sponsors are sending out to you, there is a lot of uniformity. It's not on this level necessarily, but there are obligations. So what you should be expecting and should be getting to you, certainly for my compliance officers or my compliance committee members or folks out there who have compliance responsibilities of some sort in their organization, these annual certifications are getting mailed out. We know this because my clients get them, they call me about them, they have questions about them, they worry about them. Can they make all the certifications in them? I don't know whether you're getting them and reviewing them, or that the people are reviewing them and signing them are appropriate and have all the knowledge in there, whether people are out there. If you're out there just signing these things and they're not true, if you get audited, you're going to have a problem. So understand what's usually in there. This is what I call the more measured approach using the annual certification, but here's what you should expect to be doing, okay? Distributing a code of conduct and compliance policies. It does not have to be your own. If you have your own and it's comparable, and as you can see, which is why we outlined all of those requirements before, so you can see what these plans are supposed to be doing. Well, now you know, okay, it's the 7 OIG elements. We know that our compliance, you have a frame of reference right now, as you're going through this to say, okay, we have comparable ones. And here these 90-day timeframes are popping up that we were highlighting before. Well, within 90 days of hire and annually thereafter, but you have to look at what's coming into you. You know, these vary a little bit from plan to plan. Compliance with fraud, waste, and abuse training. Again, here you have 90 days to do it and annually thereafter. Here's my caveat. This is the deemed status stuff I was talking about before. It's not, it's expressly been removed from the regulations. There is commentary in the Federal Register. If you go and you pull it, for those of you who get that deep in the weeds for the discussion on this, they pulled the required compliance training as a mandatory requirement that gets pushed down to you. They also had a deemed status where if you were, let's say, a accredited DME provider enrolled in Medicare, or if you were a Part B provider enrolled in Medicare, that you'd be deemed to have, you know, your fraud, waste, and abuse and compliance training done. That's not the case anymore. However, these plans do have leeway, and you will continue to see this language getting pushed out to you. My point is that it's not in the regulations, but they're still using it, and they would get audited for you know, looking at that with you. It still appears in the Medicare manual. Perhaps that hasn't caught up yet. It's been a few years. I think this change happened in like 2018, so we haven't fully caught up yet. And so be aware of that. Exclusion checks, you got to be doing them. You can't pay Medicare, federal healthcare programs, they can't pay for items or services furnished by or prescribed by an excluded provider. FDRs, you must be checking your exclusion databases. You get it set up, and then you need to do it on a monthly basis. That is what the OIG guidance is on it. That's what we're seeing in these arrangements. Reporting awareness. You got to make your employees aware of fraud, waste, and abuse reporting mechanisms. If it's not through you and your own compliance program and things of that nature, to your compliance officer, what gets pushed down to you for those lines of communication needs to go up to the plan sponsors. And you see in the next one is reporting the fraud, waste, and abuse. They really want that coming up to them. They have obligations to look into that and to conduct certain auditing regarding that. And I know from certain plans that come to us for help, they get audited by you know, the government for whether or not they're operating their SIUs and doing these things you know, correctly, and reporting them on to, you know, other government agencies when it comes to them. We've seen, you know, this self-auditing of first tier and downstream related entities. So a lot of you may see questions in there about what level of auditing you're doing. You may have auditing responsibilities. I'm leaving offshore operations to the end because this is one I think you all need to really listen to, because there's a lot of folks who come to me and really don't understand this obligation. It's not your typical compliance obligation. This is really a HIPAA privacy security issue, but it is in there. It's in your attestations, and there's certain obligations for offshore operations. Like I said, I'll get into those, but this is what you know, looking at all the materials you can pull out there from the different plans, things that our clients have brought to us, looking at the contract, this is really the kind of bucket list here of the things that you should be doing if you're contracted with a Medicare Advantage organization or a Part D plan sponsor. Record retention and proof in these attestations. So this is going to hit a few of the questions that were popping up in the chat. Yes, 6 years, right? That's something we've talked about many times, depending where you are. If you're contracting with these, they're expecting, you know, through these agreements, maintaining proof for 10 years. That is what has come out from CMS with them, and that is something that gets pushed down to you. On audit, you'll be asked proof of distribution of the policies. I know we had a question before, is, am I good enough by just posting them on my intranet? I don't think so. I don't think you're going to show that a sufficient distribution. And frankly, when clients come to us for compliance program help and rolling out their compliance programs, you know, one of the things we talk about is preparation of something, compliance really needs to come from the top. That's been, a mantra from OIG. It's really hammered now in these new OMIG compliance regulations. Preparing a memo, affirming it coming from the top, and blasting it out to your employees where they can locate it, and maintaining, let's say, your distribution list or your access of something, depending how sophisticated you are. Having, a lot of our clients will collect annually the, signed attestations from employees that they've received and acknowledged and will follow their compliance program. So it depends on what type of provider you are, whether you're using, your own compliance program or theirs, but you're going to have to show the distribution. If there are certain training and education requirements, you need to maintain something, whether is it collecting an attestation, is it keeping a log for that day and maintaining it? These are the things you need to produce. So your exclusion checks, it's not going to be good enough to just sit there and say, I did my exclusion check on the 30th of the month. They're really looking for, and if you get into the guidance, time-stamped type of documents that can show that when you're looking and seeing these things. Oh boy, somebody's still doing exclusions manually each month. Yes, there's services that will do it for you. There's a lot of them. If you want to reach out to me, I can tell you a few you can go to that my clients use. Boy, I can feel for you on that. That's a headache, assuming if you have a lot of people. So your attestation forms, you've got to get it signed by somebody who has knowledge of all the things in the attestation. And each year, you're going to get asked to certify this as part of your continued, being a provider in good standing. What happens if you don't meet these things? You could tell them. What happens if you don't do it?
So failing to meet these compliance obligations, you may be subject to developing a corrective action plan, retraining, or perhaps termination of the FDR contract, which you certainly would not want. Yeah, presents a problem. So, look, they pitch these things, and if a client's not in compliance from time to time, as wanting to be friendly and focusing. Even you'll see the language in their plan sponsor documents about no retaliation and things like that. The first effort is definitely going to be on just bringing you into compliance. And so let's talk about the offshore business piece of this thing, okay? So this is an aspect that really relates to your security of patient health information, okay? You are required to notify and obtain approval in advance from your plan sponsor before engaging in an offshore business or contracting with another party, with maybe a downstream entity who is offshore, okay? So when does this get triggered? This gets triggered when an offshore entity will receive access to PHI for plan sponsored members, okay? So is this a billing and coding service that's offshore? Is this medical records? Are they stored, in another country's information technology system? Is this a physician who's offshore who we're paying to do reads for us, let's say on, a radiologist? In those situations, you need to be going to your plan and applying. There's a whole application in order to do it. And by the way, it's if you're outside the 50 states, the District of Columbia, and our territories, Samoa, Guam, Puerto Rico, etc. So outside of those, you have to go in advance and get approval. And when you're submitting it, you're going to have to include a lot of information concerning the terms of the agreement that you're entering into with this offshore business, as well as the security measures that the offshore business is going to be required to adhere to. There's things about is there ability to do this without them seeing PHI, and you'll have to answer questions like that. But I have found that this one of, many of the things we've talked to today to slip through the cracks. And if you've been doing it offshore, you should be going to your, talk to your folks, talk to your business folks, talk to your counsel about going and getting yourself into compliance. So my compliance officers, what's my advice to you, my compliance folks or my business folks, those who are out there? There's these big contracts going on, okay? A lot of times
they want you to maybe be a superhero, but you're not invited to the meetings, right? Or you don't know that it's happening. Or somebody is going to enter into a contract with a radiologist group that's off-site. You don't know about it. They don't know about the contract. They don't know about these things, these offshore requirements. Make your CEOs, your business folks, your governing body, whoever it is, aware of these issues so that they can be addressed before things happen. So at the contracting stage, whether it's on those compliance, those provisions we were looking at before in the slides, or it's dealing with somebody's coming and saying, yeah, we're going to offshore all of our data, or we've got this PHI going to go to this other company. You gotta be aware of these things. So hopefully, between that and your awareness of these other things and these obligations, you found today's presentation helpful. I'll take a second to see. I don't know that I'm going to be able to answer, all of these questions. Some of them are really very specific on OMIG or, let's see. Let me see if I can, ones that I feel like I could answer for a group, I will try to answer in the next minute here. If not, you can feel free to reach out. Yeah, your preclusion list, great question. I see that one popping up in there. I don't believe you have, I think this is from Sandra. Yeah, I'm not sure how you're going to get access to that, the preclusion list. I'd have to double check. And we can look into that for you. Let's see here. Sending their own training deck required to disseminate, yeah, and certify completion. It's onerous, again, from Sandra. We could have a lot of, looks like, good things to talk about here on this issue, Sandra. Yeah, it sounds onerous. You should be able to work things out if you have your own. Take care of the question about the, what's good enough to show dissemination. Take care of the auditing question there. Good banter about exclusion lists. Thank you. Keep it fun. Forms. I think people generally ask about forms. That's something you have to reach out to me directly on. It's not, these things. Your compliance program shouldn't just be a set of just forms. It's supposed to be tailored to you, or at least understanding your provider type. So you could feel free to reach out to us separately. How would you know if your X-ray is subcontracting? It's a great question. I think those are things that, so this is from James in our question and answer, looking into those things on an offshore. These are things that you need to be considering when contracting. If you're having issues with us, with this, you can give us a call to discuss it in more detail. But I'll say, like, when you're contracting with those who potentially are going to subcontract out, usually those are things that get contemplated and put into the agreement that either, or they have to notify you, can't do, or if they choose to do it, can do it within the states, or have to come to you first for approval. So there are ways to contract and address those types of issues. Yeah, I see a lot of people dealing with these things that are onerous, and the exclusion checks are one of them. But there are, I saw somebody, I forget who it was before. If you reach out to me directly, I can point you in the right direction to make the exclusion checks far less rigorous or onerous rather, and also it's not that costly of a thing according to what my clients have told us. So. We appreciate, that's really the most of what we can get through, I think, kind of auditing and monitoring activities would you recommend to ensure compliance? Good questions. If you go and you look at, if you're either a New York provider, what are your risk areas, or any type of provider, what are your risk areas? Where are you subject to potential risk of abuse or fraud with respect to any of these federal healthcare programs? Those are areas that you would look to audit, whether it's billing, whether it's coding, medical necessity, things of that nature, depending on your provider type. There are other things within there. Hiring, you can hire consultants to assist with that too if you can't do it on your own. certified coders can come in and help with certain types of auditing, looking at your contracts to ensure you have, the applicable provisions. Those are types of things that would be common to recommend. So I want to thank you all very much. Again, next month we've got one getting blasted out from our Florida office regarding telehealth. And then after that, come on back. I know I'm going to guess it's going to be a packed house for the Eliminating Kickbacks and Recovery Act discussion and update, because there has been a flurry of kind of activity going on. And I hope you all continue to come and reach out to us. A number of you after the last one reached out afterwards. Appreciate the feedback, and if we can help you in any way, always feel free to give us a call. Thank you so much, everybody, and have a great day.